Good evening, ladies and gentlemen. I'm Jeff Badnock, and on behalf of the organizing committee, it's my pleasure to welcome you to our fourth lecture in this 20th year of the Alumni Association Community Lecture Series. This series, as I've told you before, was created to showcase the research and interesting work that's being done on the University of Montana campus and to give the community an opportunity to learn more about what's going on. Over the last 20 years, we've heard amazing lectures about a wide variety of subjects. There's a lot of very, very interesting things going on here, a lot of cutting-edge research that's going on the university campus, and the organizing committee is just thrilled every year to come up with topics to showcase for you. 2 weeks from tonight, we'll have our final lecture, which will be a panel discussion, kind of wrapping everything up on the topic of what do we know and how do we know it. Along with that final meeting, we're going to have a reception where we'll gather with refreshments, and you'll have an opportunity to speak with our lecturers and follow up on things that you might have heard about, were curious about, and continue the discussion. As always, each lecture will be followed up by Q&A. Because we are having the lectures videotaped by MCAT with a media assistance grant from MCAT, we'll provide microphones to capture your questions. So just raise your hand. Somebody will come to you with a microphone. Speak clearly into the microphone so we can make sure that we get down everything that you want to learn about. As always, please silence your telephones. This year's lecture series topic is Beyond the Headlines, Clearing the Air with Real Evidence. The series began with the first 3 weeks with information about wildfires, what they are, why they are, and how they affect us in our communities. This week, we're going to pivot and move into the field of law. And to introduce this week's lecture, I'd like to ask you to join me in welcoming Dr. Sarah Renfret from the University of Montana Political Science Department.
So good evening, and thanks so much for coming tonight. We have a really fantastic speaker for this evening, and so it's my pleasure to introduce her. And so like Jeff stated, we are pivoting a little bit tonight, and so we've been focusing on the complexities of our natural environment, but it's also to take a lens through the social science perspective, and so looking at evidence-based practices, but also more specifically looking at the complexities of our social environment. And so this evening, it's my honor and privilege to introduce my friend and colleague, Professor Jordan Gross from the School of Law. And Professor Gross is a Montana licensed attorney. She also teaches courses in the Alexander Blewett School of Law in criminal procedure, white-collar crime, federal courts, and professional responsibility, all classes that I would like to take someday. And she also supervises law students doing clinical work with state, city, and federal prosecutors. And she received, and before joining the law school in 2010, she worked for a litigation firm in Seattle where she was a partner, and she practiced federal criminal law. She received her undergraduate degrees in political science and English literature from the University of Washington, and her law degree is from Howard University in Washington, D.C. She is passionate about leveling the playing field for low-income individuals, and she regularly volunteers at a free legal clinic that serves low-income Montanans. She's actively involved in state organizations and initiatives that promote access to justice. So without further ado, let's welcome Professor Jordan Gross.
Thank you, Jeff. Thank you, Sarah. I'm going to move this because I'm at risk of tripping over it. Although this is a lecture and we do need to record questions, I will tell you I am a teacher by trade, not a lecturer. So if you do have a burning question you would like to ask in the middle of my presentation, I encourage that. In fact, either Sarah and I can bring you that mic if that would be helpful. First of all, I want to thank you for the opportunity to come talk to you. I have been living, breathing, researching, teaching criminal law and criminal procedure for the better part of 25 years, and I love this stuff. So I love any opportunity to come tell people what I'm working on, and also let you know how lawyers look at these problems, how lawyers process some of these social complexities that Sarah referred to. And so my goal tonight, really, it's not to kind of hold up a reform, say good reform, bad reform. My real goal tonight is to help you unpack reform. What does it look like? What do we mean when we're talking about criminal justice reform? And I'm going to give you 3 examples. One, a completed reform. One, a reform that is kind of inconclusive, hasn't really resolved itself. And then talk about a couple recent criminal justice reforms in Montana. And my goal is really to help you become a more educated consumer of reform, of criminal justice reform. So when the next reform comes around, and it will, right? This is an iterative process. The criminal justice system is in a constant state of flux and reaction. That you will have the tools and the information that you need to ask the right questions and to think about reform in a really sort of systemic and analytical way, so you can be a more informed consumer and a more informed participant in criminal justice, okay? To do that, I'm going to give you the evolution of American criminal justice system in 5 minutes or less, just to make sure that we know where we came from so we understand how we got where we are. Of course, most people know that the American criminal justice system, most of it is borrowed from common law England. We brought a lot of it over. The Europeans brought a lot of it over. Of course, there was many existing native justice systems, but for the most part, the American criminal justice system has supplanted, except in Indian country, has supplanted whatever native processes were in place. So we do have to talk about common law England so we can understand what our justice system looks like. Now, common law, criminal law was considered a private matter, okay? People sued other people over injuries for money, okay? Women were considered property of men, so if a woman got assaulted or raped, that was an offense against her husband or her father, who could then sue the assailant or the person who injured the family for money damages. So most private justice, and that was the origin of our current tort system, right? That's how we seek or recompense injuries in the American criminal justice system, is with money. That was the origin of criminal justice. It later evolved to a public justice system. So an offense against me became an injury against the crown, okay? And we brought that over to the United States, brought it over to the colonies. So an offense against me is now an offense against the state of Montana or the United States government. So when you see a criminal case caption, USA versus Gross, right, it's because my conduct is seen as an offense to the public, and it is being vindicated by the sovereign, by the government. And now where we find ourselves, so it's still a public justice, but it's much more professionalized justice. It used to be justice was administered by private individuals, and then really by lay people. There was a time in the United States when most lawyers and judges they read for the law. They weren't law licensed. They didn't have JDs. Of course, that has all changed. And if you look throughout the criminal justice system, it has become highly professionalized, for better or for worse. But I think one of the downsides of the professionalization of justice is that it's a little hard to access for lay people. Okay, then versus now, a couple of key features and some themes we might return to. It used to be that criminal justice was about confession and reconciliation with the community. Okay, that was the goal, was I would confess to my crime, I would do whatever penance I needed to do, and then be restored to community. Our system of justice now is about plea bargaining. Upwards of 95 to 98% of criminal cases in the federal and state system, and probably in the tribal systems as well, go away by means of plea bargaining. So to plea, you have to confess to certain conduct, but it's not the same thing as a public confession, a public punishment, and then restoration to the community. So common law, and in the colonies, there was really most offenses could be addressed this way, and then the extreme offenses were either punished by death or by exile. Okay, not a lot of middle ground between those. But now we have a plea bargaining system, and that contributes, I think, to some of the lack of transparency in our system. We no longer really have public trials. That was a key feature of justice in the colonies and in the early United States. So there's something cathartic for the rest of the public. It's a morality tale. It's a morality play, and we don't really get that anymore. Very, very few things actually go to trial. They go away by plea. It used to be punishment was about public shaming, okay, putting people in the stocks or public punishment. But the idea was you would get your public punishment and then be done and then come back to the community. Now we lock people away. Its primary means of punishment now in the United States is we detain and incarcerate people, okay? And one of the key features of early justice in the United States and the colonies, it was transparent. So that the public trial, the public shaming, you did something, I got to see the judgment by your peers, and I got to see the punishment. And now it's really much more opaque. So we lock people behind bars. We don't see them. We don't hold trials anymore. So it's harder and harder, I think, for lay people and for the public to get that sort of involvement that used to exist in a more public justice system. As I said, it's not a judgment, it's just kind of an is. So I think that was about 5 minutes. Did I do it? Excellent. All right, then. So here's what I want to talk about today is the anatomy of reform. And as I said, I want to talk about 3 distinct reforms, movements, if you will, that one with a profound impact that we're still dealing with and still trying to unreform, if you will. And to do that, let's talk about the different parts of the anatomy. So you and I are going to be kind of like physicians or maybe more like performing an autopsy here, okay? So we can sort of pick this apart. I think the first question we have to ask ourselves is, well, what's the subject? So what part of the system is this reform targeting? Is it punishment? Is it perhaps the trial procedure itself? So thinking about, okay, so when somebody comes and talks to you about a reform or wants you to sign an initiative, think about, okay, what's it trying to do? What's this geared towards? This one's really important. Who's the source? Who's asking for this reform? Who wants it? Okay? Is it a politician? Is it the people? There's all sorts of different places that the source of the law can come from, reform can come from. Again, who supports it? Who opposes it? What's the narrative? We're going to talk a lot about narrative of criminal justice reform. And the evidence. That's part of tying into our lecture series here. And I think the evidence piece that is most important is there a problem? I think that should be your first question, okay? We have seen reform for reform's sake in the criminal justice system, no question about it. And if there is a problem, will this particular reform address it? Will this reform do something? And what's the evidence behind that? And finally, what are the results? What's the goal of this reform? Are there likely to be unintended consequences? Okay, so let's talk about subject. And here's just part of kind of orienting us more towards the material. In criminal law, we talk about 2 parts of the law, the substantive criminal law and the procedural criminal law. So substantive law is what is criminal? All right, what conduct is criminal? And as lawyers, when we say what is criminal, we'll have a statute. In Montana, murder is called deliberate homicide. And to be found guilty of deliberate homicide, the government has to prove A, B, C, and D. Those are our elements, A, B, C, and D. So we have to define, well, what conduct is criminal as opposed to civil, or as opposed to not within the reach of the law. I should note, when we're talking about what is criminal, some conduct is beyond the reach of the state and the power of the state to criminalize and to punish. A couple examples, things that used to be criminal and no longer criminal because the U.S. Supreme Court has says, hey, states, you can't punish this. So consensual homosexual adult intercourse. Okay, Texas versus Lawrence. Texas, that used to be a crime in Texas. U.S. Supreme Court said, no, that's beyond the reach. Some things you can't make criminal. Interracial marriage used to be criminal in some states. You can't make that criminal. So thinking about that. So what is criminal? What is beyond the power of the state? Who is a criminal? In the legal realm, we have things called status offenses. So things that are only criminal because of the status of the person. Juvenile offenses. So there might be things that a juvenile does that are not criminal if I do them. Felons, felon in possession of a firearm. I can own a firearm, but if I'm a felon, maybe I can't. Okay, so that's what we call the status offenses. A really important category of that are the habitual offender laws, popularly known as 3 strikes you're out. So remember those? Okay, we still have those, but those are very much status offenses, meaning if I commit one crime, having already committed 2 or 3 predicate offenses, ones that count, that's a separate, can be a separate offense or a separate sentencing enhancement. So that's punishing me for doing something on a particular status. Where is it a crime? Jurisdiction is hugely important to criminal defense lawyers and criminal prosecutors. So one piece of conduct, one act, can be a crime committed in one place, can violate the law of multiple sovereigns. So I could commit a crime here in this building, I won't, but I could, that could violate both state and federal law. Or I could be an Indian country and violate a law that is both a tribal offense and a federal offense or a state offense. So just think about it. It's what we call concurrent jurisdiction. And I think it surprises people to know that if I commit an offense against Montana, and I am tried and convicted and punished, the federal government can come punish me as well for the exact same conduct. There is no double jeopardy bar for concurrent jurisdiction crime. So where is it a crime? That matters. When does it have to be prosecuted? We have statutes of limitations. We call them statutes of repose. Only one crime that doesn't have one, murder. Pretty much everything else, we say, hey, state, or hey, federal government, if it's that important to you, you'll go out and prosecute it in time. Otherwise, we let people move on and put that in their background. So everything but murder has some sort of limitation, says you have to prosecute at a certain time. Okay, so that's what I would call the substantive criminal law. Now let's talk about procedural criminal law. This is where I hang out. Love this stuff. This we call bail to jail, okay? This is the how. Those are the who, what, whens, but procedure is the how do we do it, okay? How do I process people from bail from the time they are charged, right, and taken into custody until they are sentenced, okay? That's my bail to jail piece. And this matters a lot. I teach criminal procedure, and it's really constitutional law in disguise is what I call it. It's heavily constitutionalized. So that's our how. And then, so I think of this as the front end. You know, maybe it's a sandwich. That's the middle, the procedural part. And then we have the back end. We actually have remedies for defendants and offenders and people who have been convicted, civil remedies, post-conviction statutes, habeas corpus, okay? So once you've been convicted, it's a way to redress a wrongful conviction, and civil rights lawsuits, okay? So that's kind of it. That's your criminal justice system right there. There's your package. That's what we're working with. So let's talk about sources of reform, sources of law, and support. So that's the next thing I would ask you to think about if presented with a reform or somebody wants to discuss it or wants you to sign on to something. Say, okay, well, where's this coming from? Okay, where does this originate? Some reforms come from the federal courts and Congress. So I think about, when I think about federal court reform, the U.S. Supreme Court might say, of course, that's the supreme law of the land, the Fourth Amendment requires this, or the Fifth Amendment requires this, or the Sixth Amendment requires this. And that you can discuss and have opinions on, but you don't get to really change it. You're like, okay, that's cool. Okay, so when the U.S. Supreme Court says something, they set the constitutional floor for the rest of us. And so there's not much to do about it. It's not like Congress can come and override the court unless the court says it's not a constitutional matter. And then Congress, the U.S. Congress, of course, is a huge source of statutory reform. Congress plays an outsized role in criminal justice in Indian country. I do a fair amount of research in that area. The U.S. Bill of Rights does not apply in Indian country. The Constitution does not reach Indian country. But Congress passed a law in 1968 called the Indian Civil Rights Act that does set procedural limits on tribal governments in tribal court. So that's a lot might come from there depending on where the jurisdiction lies. And of course, state, tribal, local courts or lawmakers, they might institute a reform either by statute, a case, a rule. So it's coming from all sorts of places. The legal profession. We have, of course, a governing body. It's the ABA. And the ABA doesn't always speak for all of us. However, I can tell you when the ABA does speak, it generally represents a consensus of the legal profession. A lot of really opinionated lawyers with a lot of agendas in the ABA. So when the ABA comes out with something, that tells you that's a hard-fought product. That means the lawyers have been working a lot and come to some sort of consensus, some sort of position. So the ABA actually has criminal justice standards that has some, and there's a lot of, I think the big point about that, there's a lot of thought and a lot of research that goes behind it. So if you see something coming out of the legal profession, it could be that it has quite a bit of, at least a lot of thought behind it. We also see advocacy and policy groups might promote or suggest reform. On both sides, every side of the spectrum. And then the private sector. This is kind of interesting to me. I think one of the new features of criminal justice reform is more and more involvement from the private sector and more involvement of wealthy individuals, rather than just giving their money to an organization that does the work, actually creating their own organizations. We see it in the health field, and we're certainly seeing it in the legal field as well. I say the people, question mark. Two reasons I have the question mark there. One, in some states like Montana have initiative processes, so we can actually propose laws and get them on the ballot. California, it's more common in the West than in the East. But I also put a question because sometimes things that look like they're coming from the people actually may be coming from the private sector or from advocacy groups. So I think that's something to keep your eye on. So when you're out in the world and people want to talk reform, ask, where's this coming from? Who's funding this? Who's behind this? Because it'll help you at least understand what the motivations might be. Okay, so let's talk about our first category of reform. I call this the war years, the war on crime, the war on drugs. We spent close to 30 years fighting a war. Drugs, crime, whichever one it started as Nixon's war on crime and eventually became the war on drugs. So the other thing I want you to be thinking about, the source, who's behind it, who's proposed it, is what's the narrative, okay? Because the narrative does change. Remember, way back in the day, this used to be a morality play. And I think that narrative has changed quite a bit. So let's talk about the narrative. So I think I'm not going to make any presumptions. I'm old enough to remember this, and there might be other people in the room who are old enough to remember this. Okay, this was the narrative. Crime is rampant. It's a failure of the criminal justice system to punish properly. Criminals were escaping punishment because legal technicalities, liberal judges, and permissive laws. Therefore, we need certain and harsher punishments. Does anybody remember this? Yeah, right? War on drugs, war on crimes. All right. So what did we get from the war years? Mandatory sentencing guidelines. It started as the Sentencing Reform Act on the federal level. And many states, not Montana, but many states followed suit. And with the mandatory sentencing guidelines, where they actually started, I think, from a benign place or well-intentioned place. And the idea, at least on the federal level, was it wasn't just and equitable that somebody could commit a crime in New York and commit the same crime in California and get a vastly disparate sentence, okay? Because when we're talking about federal courts, it's a unitary court system, even though they have multiple courts throughout the country. So the idea was one federal law should reap the same punishment for the same type of people. That was one. And there was a concern, I think a legitimate concern, I'm not sure this addressed it, of racial disparities, right, in federal sentencing. So the idea was, well, let's quantify all this, okay? let's put numbers on everything. We'll give you an offender score, and then we'll tally up the points, the characteristics of this particular crime. I wish I'd brought my reform guidelines with me, my sentencing reform guidelines. And it has like seriously a table. You just go, well, here's my offender score, and here's my offense level, and that spits out a number, right? Justice by numbers. And it gives me a range. It gives the judge a range. And when these were mandatory, the judge had to sentence within that range. She had no discretion, okay? And failure to sentence within that range was mandatory reversal by the reviewing court. I came up in this system. I was in federal criminal defense, and you could pretty much guarantee what somebody was going to get, certain amount of drugs, certain amount of money. They're very numbers driven. So in a fraud case, I handled a fair amount of those. It's driven by the amount of the fraud. Okay, and then the offender score. How many priors do you have? And you could tell somebody. And that did contribute quite a bit to plea bargaining in the federal system, because who's, with these high drug offense punishments, who's going to go to walk somebody into a life sentence when you can plea them out for 10? Okay? But that was one product from the wars, was the mandatory sentencing guidelines. Many states jumped on the bandwagon. Washington State, where I practiced, had its own. Montana kept its indeterminate sentencing, meaning judges can impose open-ended laws or open-ended sentences in Montana. But the idea behind this was to even out disparities, but also, very importantly, to cabin judges' discretions. Those darn liberal judges that were letting too many criminals go, according to the narrative, this way we could force them, right? So what we saw was an increase in sentences and a decrease in the ability of judges to show leniency in individual cases. So taking that kind of that morality piece in, but adding this, I think was considered numbers-driven and data-driven approach. Revised habitual offender laws. So many jurisdictions already had these, but they kind of got dusted off and fluffed up and made stronger during these years. And we already talked about that they're also called persistent offender laws. So it makes it's a status offense to commit a crime having committed previous crimes. So we saw more, heavier use of those and revised use of those really long drug sentences. At one point in Michigan, you could get life without parole for a first-time nonviolent drug offense, felony drug offense. And the U.S. Supreme Court said that's not excessive. So if that's not excessive, I'm not sure what is. They've since revised their law, but those were routinely being imposed and being upheld by the U.S. Supreme Court. The U.S. Supreme Court has never cabined states' ability to impose harsh sentences for nonviolent offenses. And of course, the mandatory minimums. So a statute, if you open a statute book, and the criminal law says punishable by up to 20 years. Okay, so that's as high as a judge can go. Mandatory minimums are on the other end. That's the lawmaker saying, Judge, you can't go below this. You may not sentence to less than 5 years, or less than 10 years, or less than 20. So we saw a proliferation of those. There are some in the federal system, there's some safety valves to those, but just that was a new feature. So we want to keep those judges in line, right? Keep them coloring within the lines. So those are some of the major reforms we got from the wars. Okay, so what were the results? What's the result when you have harsher laws, more criminals? This isn't going to be hard to figure out. What? We have a lot of people incarcerated, okay? This is current, 2.3 million people incarcerated in the United States, and that's in all the facilities. So that's adult and juvenile, state, federal, and tribal prisons and jails, immigration. That's kind of the sum total of number of U.S. residents who are locked up. And this is an important piece. Most are in state or in county jails, state prisons, county jails. When you think of the federal government, it tends to have an outsized influence sometimes, but in the whole criminal justice pie, it only occupies a little piece of that. The vast majority of criminal law and procedure unfolds on the state and the county level. States take care of most criminal conduct. And that's just some sources. All right, so let's talk about the difference between jail versus prison. Jail, of course, is short-term detention, a year or less, typically. Somebody in jail is either convicted of a misdemeanor offense, something that is less than 1 year jail time, or they're awaiting trial. Somebody who goes to prison is there because they have a sentence of a year or more. Big difference between prison and jail is jails are set up only for short-term detention. There's not a lot of educational facilities. That's not the idea behind jail. The idea behind jail is we're just going to hold you for a little bit. So there's not a whole lot of investment in activities and education long-term that you see in long-term housing. So prisons, at least nominally, are supposed to be geared at improving and reforming people so they can rejoin society. So here's some numbers for you. 11 million jail admissions per year in the United States, probably about 9 million individuals. So we might have some frequent flyers. But that's 9 million people going in and out of jail every year in the United States. And this is where I'm spending a lot of my research time right now. 70% of them are pre-trial detainees. These are folks that have been arrested and charged but not convicted. They're presumed innocent. And 70% of the folks in jail in the United States are folks who are presumed innocent, have not been convicted of that crime. So on any given day in the United States, 500,000 people are in jail waiting for their trial. Excuse me. So this is a nice visual here. So here's what I was talking about. Here's the pie. This is federal right here, okay? So you can see comparatively, most of this belongs to state and local jails. So this is going to be state and county right here. Here are the folks. These are our pretrial detainees who have not been convicted of any crime and presumed innocent. Here's our short-term detainees, so our misdemeanants. And this is another important piece to look at. So let's look at the crimes. You know, almost half of this part of the pie are violent offenders. Okay? And this comes from this little wedge here. You can see Indian country is a small fraction, military civil commitment. Immigration, this is all federal. It's right in there. And then the juveniles are right there. Okay? So it looks like, fully almost a quarter of people sitting in jail have not been convicted of a crime. They're being detained and housed without being convicted. All right. So let's do a little comparison. We're still on results. What did the war on drugs and the war on crimes get us? So we have a crime rate that's comparable to other politically stable industrialized nations, but an incarceration rate that's about more than 5 times higher than our comparisons. Here's who comes close to us: Turkmenistan and El Salvador, countries with a history of social and political unrest. And they're not even in the running, but they're close. Vermont and Massachusetts incarcerate the least, the fewest amount of people, our percentage of people. So shout out to Vermont and Massachusetts. However, if they were nations, they would still rank 11th and 12th in the world. Okay? So even the more progressive, if you will, amongst us are still locking up quite a few people. Here's just another visual. So here's some, I know, don't you like how they did this? Like, we didn't even fit in the box. Okay. So here's our founding NATO members. So, industrialized, politically stable countries. And that's how we stack up with other nations around the world. Okay. So this is another important piece. So, we look at targets, then who's impacted? So we look at what part of the system is this reform targeting? Well, who's impacted by it? This is the general, the demographics. I've just put in the two most relevant nationally are white and black. And then you see our incarcerated population. So clearly disproportionate to the general population. Mostly male and mostly poor. Most people in the criminal justice system qualify for indigent defense, meaning they qualify for a public defender, which by definition means they're poor. It's the vast majority of folks in our system are poor. How about Montana? Here's our general population. And a huge disparity here among white Native Americans. And this number, I didn't break it down by gender, but there's been just an exponential increase in the incarceration of female Native Americans in Montana in the last several years. So our state, this is still Montana, our prisons and jails are either overcrowded or at capacity. These are the increases. There's some sources. So here's the increase of prison population and then the county jail. This is averaged out. We obviously have multiple jails. And we have one main prison in Deer Lodge, but we also have private prisons in Montana as well. So this is average for those facilities. Okay, so we had a big reform that went for about 30 years. This is what we got. And who won? I know who lost. Poor people, people of color, taxpayers, just saying. So who won? So we saw a rise of private justice in the sort of the prison industrial complex. Quite a bit of money to be made off housing folks, okay? Feeding them, incarcerating them. Court orders to reduce overcrowding. So many state systems have been operating under federal court orders to do something. California, most notably, California, you might remember, led the charge on 3 strikes, you're out. And now they're operating under federal mandates to depopulate their prisons. But sometimes court orders to reduce overcrowding were often reinterpreted as mandates to build more prisons. Like, oh, wait, you don't want us to house this many people in this little space? Let's make some more prisons. Who won? Correctional Officers Union often opposed reformations of laws that would have reduced the incarcerated population. All right, this is what I'm working on right now. Bail bonding. International insurance company. Bail bonding in the United States is a multi-billion-dollar industry. And I think when we think of bail bonds, we think of like Crazy Mike's or whatever. You know, you see the signs, Liberty Bonds. But those are actually backed by international surety companies, by major insurance companies. And bail bonding is just one part of their portfolio. So the Crazy Mike or Crazy Michelle or whoever it is who actually bails you out, she needs to buy insurance from an insurance company in case you take off and she's left holding your bond. So she doesn't have that money. It's the insurance companies behind her. And these are major, major insurance companies, and it is worth a lot of money. Okay. So postscript to the war on drugs, and we'll move on to our bail reform, which is the next thing I want to talk about. This is a lot, but I think this is really, really important for us to at least think about. John Ehrlichman, this is Nixon's domestic policy chief, gave an interview to Harper's Magazine in 2016, 2 years ago, about the war on drugs. And he said the administration had 2 enemies, anti-war left and black people. Can't make it be illegal to be either of those. But if we can get the public to associate blacks and the anti-war left with drugs, and we criminalize that heavily, we can disrupt those communities. We can arrest their leaders, raid their homes, break up their meetings. Do we know we were lying? Of course we did. And I put this up because if you think about it, it's all a matter of perspective. Was the war on drugs, was that reformation of the legal system a success? If you go by this measure, it was a resounding success, right? We've disrupted communities, particularly nationally in the African American community. We have taken generations of young men out of the community, right? And that has tremendous impacts on their communities, their families, but it also leads to disenfranchisement. So it can have political repercussions as well. In many states, you lose. In Montana, we automatically get our right to vote back. In many states, you have to petition to get the right to vote returned to you. And that can have significant impacts in jurisdictions with large African American populations can have political impacts as well. So I'd say it was a success. Not one I love, but if this is what they were out to do, they did it. Okay, let's talk about bail reform. So I'm spending a lot of my time right now is thinking about bail reform. And I find bail reform to be really interesting because it is one of the longest running, most incomplete, most inconclusive reform movements in the United States. Okay? We've been at this now since the 1960s, talking about bail reform. What are we going to do about bail reform? So a couple things to know about bail reform. So we already talked about this. we're talking about 70% of jail inmates possibly impacted by bail reform. Money bail is just cash for pretrial liberty, okay? That means I get arrested, judge says, set your bail. We just had these 2 young men who were arraigned recently for attempted deliberate homicide, $1 million each. They're 18 and maybe 20, I think. You think they got $1 million? No, they don't. That's why it was set at $1 million. They're not going anywhere, but that's what that means. So you can't pay? You can give 10% to a bondsman, non-refundable. You don't get it back. Win, lose, or draw, that's their fee, okay? Or you can stay in jail. Those are your options. So if you have $1 million, you can post it and get out. If you post it with the court, you get it back later, maybe a small fee off for court processing. Or you can find a bondsman, okay, to pay 10%. You give 10% of the bondsman's backed by the insurance companies, and you get out of jail or you stay in jail. Only 2 countries permit for-profit bonding. You know what one of them is. Does anybody know what the other one is? The Philippines. It's actually illegal in many countries to engage in commercial bail bonding. And getting to our evidence-based theory, or theme, excuse me, there's broad evidence-based consensus in the legal profession. I don't include the bondsmen in the legal profession, okay? They would vehemently disagree with me. It harms poor defendants. Even short-term detention can have significant and long-lasting impacts on poor folks. They can lose their jobs. They can lose their children. They can lose their apartments. But I think more disturbingly, they are exponentially more likely to plead guilty, to get the heck out of there, right? And they're more likely to be convicted. It's really hard. I was a criminal defense lawyer. It's really hard to work with somebody who's in detention. You have to, but you got to go through the security, and you have to set up time. So it's a lot easier to defend somebody when they're at liberty. Right? They can help you. They can help you track down witnesses and evidence. Okay, so we know there's no question that it harms poor defendants. Okay. And there's lots of evidence and lots of science on this. I'm happy to share if anybody, I can give you some citations. And it has marginal safety benefits. Ostensibly, the reason we keep people in bail or keep people in jail pending trial is to keep the community safe. But what they found is that as long as you can peel off the folks who present a community danger, keeping a nonviolent, low-level offender in jail it doesn't keep us safer, but it costs us a lot of money. It's way more expensive to spend 1 day in jail than to let somebody out on conditions, okay? Conditions might be GPS, might be house arrest. There's a lot of ways to put people in the community that you and I are still safe, and where our pocketbooks aren't that much lighter. It's extraordinary. The single most expensive way to punish somebody is to put them in jail or prison, by far, because you have to give them food, round-the-clock supervision, medical care, everything that somebody needs, you got to take care of once you take them into your custody. Okay. So the bail reform movement in the United States has had 2 iterations. The first time was in the 1960s and 70s. We got a couple things out of it. We got the Federal Bail Reform Act in the 60s. It was later revised in the 1980s. And in the federal system, that's where I practice my criminal law, money bail is unheard of. Technically, it still exists. People say it's a no money bail jurisdiction. That's not true. It exists. Nobody uses it. So in the federal system, if somebody's a danger to the community, you hold them. And if not, the presumption is you let them out on the least restrictive conditions possible. Right? I never had a defendant who had money bail set in the federal system. Not once. They had to give up passports or agree to certain restrictions on their liberty, but never money. So what we got out of the bail reform in the 1960s and 70s, however, was this wide variety in the state and local jurisdictions. So what came out of all this is some jurisdictions outlawed commercial bail bonding. They said, done with it. Okay? Kentucky was the first in 1974. Some states kind of followed the Federal Bail Reform Act. So yeah, we're going to go to this conditions-based type of pretrial detention. And then some states like Montana, we just held fast to bail bonding. So if you were to look at a map of the United States, and you can find this, to talk about where is bail bonding used, where is it legal, it's just all over the place. There's no consistency. So what happened? There was a momentum. I mean, it's just crazy. Like, all these states were changing their laws. Like, yeah, this is bad. This doesn't work. It's expensive. It harms poor people. War on drugs happened. Right? Kind of stopped that reform in its tracks. And the bail industry and the insurance companies happened. Once the bail industry and the insurance companies kind of saw some of the handwriting on the wall, they launched a full-on offensive. Lobbying, campaign contributions, all just have thrown a lot of resources at this issue and continue to do so. And wouldn't you? It's a multi-billion-dollar industry. I'd fight to protect it too. Can't blame them. So that's our bail reform. And so keep your eye on this. There's so much going on right now. This is front and center of criminal justice reform right now. New Jersey, the entire state, went to a no-money bail system within the last, I think it just became effective this January. So they amended their constitution. New Mexico has amended its constitution. So a number of states have looked at the evidence and said, we can't rationalize this anymore. But the only way to kind of get the bail bond industry out is really to amend the law and amend the Constitution. So a number of states have moved towards no money bail, and that has particularly brought on a wave of litigation from the bail bond industry. So it's kind of a full-on brawl right now, and one that I expect will reach the U.S. Supreme Court at some point. So keep your eye on that one. Stay tuned. So let's talk about two criminal justice reforms that recently occurred in Montana, and talk about some of the themes that we've been discussing tonight. So Marsy's Law, does everybody remember this? Came up recently. Crime victims' rights. So let's talk narrative. Who's anti-crime victim? Not me, okay? But it matters. It matters. You know? So we're talking about the subject, and we're talking about, okay, what are we trying to do? So things like this can have a lot of emotional appeal in the legal system and among people. Because really, like, who's anti-victim? I don't know anybody who is. So this started a long time ago as a proposition in California in 2008. This was actually part of a national movement. Here's the states that have recently adopted some version, including Montana, some version of the Marsy's Law. And what it is, it's just basically a list of things that crime victims get notice of this or right to participate. And I think what many folks didn't realize and still don't realize is a lot of these rights that were enumerated already existed in the law. So some of it is a little duplicative. A couple states are also considering adopting something like this. We approved one, a version for a 2-to-1 margin, which is pretty impressive. There was no organized opposition to it, but also no support from the legal profession either. Okay? So remember when I asked you, think about who's the source, and I said people, ? It was by initiative, which is ostensibly by the people. But whose result? Who is behind it? What were the results? This is actually 25-plus year campaign by one individual, a California billionaire, whose sister was tragically murdered. And I think the day after her murder was arraigned, he and his mother he's out on bail, talking about money bail. They ran into his sister's murder in a grocery store and thought, why didn't we know he was out? So he says, we need to change the law. Spent 25 years and $4.9 million in California. Finally got it passed in California in 2008. And then he started a foundation, Marsy's Law for All. His goal is to amend every constitution, state constitution, and the U.S. Constitution to include the bill, victims' crime rights. So I'm asking the source. So this is how much they spent. 94% of that was his money to help us pass a law that some people think was maybe a little redundant or unnecessary. So they didn't oppose. ACLU prosecutors and defense lawyers woke up after it got enacted. It's like, wait a minute, this is problematic. They sued, claimed violation of single-issue ballot requirement in Montana. When we have a ballot initiative, it can't contain more than one issue. It needs to be segregated into separate ballot measures. So for those reformists among you, take heed in Montana. Don't lump it together. Don't aggregate. You're going to have to bust it up because our Constitution requires it. And the Montana Supreme Court voided Montana's Marcy laws in 2017. Now, mind you, it didn't say it was unconstitutional or wrong or inappropriate. It just said it was presented improperly. So stay tuned. But now you'll know some questions to ask, right? If it goes around for another initiative, you might ask, well, what's the source? Is this an organic, homegrown thing? Is this something we need? I think that's the most important question. Or is this part of a national movement? And this is the important piece. So one thing we wanted to talk about today was unintended consequences. The states that have adopted some version of Marcy's law have found out, first of all, they got to hire a bunch of new people, additional prosecutors. The city attorney in Great Falls estimated that they would need to spend about $90,000 new money a year to implement Marcy's law. That's just one jurisdiction. And so what states are finding is there's delays and backlogs in trials that actually are probably harming victims, if you think about it that way. So, because all the notification. So just know that that's a, good, bad, or not, but that is a consequence. Once you add more procedure to the process, you're going to slow things down. Next one I want to talk about is the Montana Justice Reinvestment Act of 2017. Are everybody familiar with this? So we passed the legislature passed an omnibus, meaning an all-encompassing criminal justice package. It was a series of bills. It was bipartisan, had bipartisan support, and full support of the governor. So what did it do? Professionalize our Board of Pardons and Parole, created some new programs. Okay, so this is what I want to focus on, though. So it eliminated jail time for some misdemeanors, going after that incarceration rate, reduced maximum sentences for some felonies, and eliminated mandatory minimums for some felony drug offenses. And remember, we've been talking about this, the persistent offender law. It used to be in Montana, you only took one subsequent felony. Now you need two prior felonies to be a persistent felony offender, and one of those has to be a violent or a sexual offense. So making it harder to use that law, okay, restricting the use of that a little bit. So the narrative, though, of the new reform sensibility is, I think, worth talking about. We talked about the narrative of the war on drugs and the war on crime. So we're focused on corrections now. Most it's about, most of the narrative in the media and what's been reported is what we're trying to do is reduce prison populations, all those big numbers I presented to you at the beginning of this talk. The fiscal concerns were the primary reason to reduce prison populations, but we're not talking about the non-financial costs. All right? So I think this is something that we left behind. My very first slide when we talked about the morality play, about having the public invested in justice, and there's something different about criminal law than any other area of law, and that is our desire to see justice, both for defendants and for victims and for society. And we're losing that in our current reform sensibility. It's all about, here's some of our buzzwords: right on crime, smart on crime, assistant, reliant, reinvent. We're talking like a bunch of business people now. I don't say that's a bad thing. It's something for you to pay attention to. The language has changed around reform, and it's not about the human costs and the human justice costs of mass incarceration. It's about saving money by getting people out of prison and jail. So the Montana Justice Reinvestment Act, it's our law, but it's part of a much broader national movement. Again, something to pay attention to. What's the source? Where's it coming from? So these reinvestment acts, and you'll notice the title, Reinvestment Act. So I want to know, does that mean all this money we save, we're going to reinvest it in social programs? Or are we just saving money, okay? There's no part of that law that says we're going to take this money and put it into something else. We're going to reduce our costs. But it's based on a national model of a nonprofit center for state governments, kind of a think tank. It's a nonprofit, nonpartisan think tank that comes up with model laws. And so ours is almost directly out of their Model Reinvestment Act. And our legislators, of course, they tailored it to us, but no, this is part of a bigger national discussion. This isn't something we came up with. This is part of a larger movement in the United States. And I just have to put this up. I told you a lot of this is couched in business speak. Here you go. This is from the Montana state government website. I'll just let you read that. Data-driven threat. So I ask you, where is the part about morality, right, and human cost? But this is our new language. This is what we're talking about now, today, in 2017 and 2018. Something to pay attention to. And I think this is one of the most important pieces of the research of other scholars that I've been looking into, the suggestion that these reinvestment acts aren't perhaps as broad and comprehensive as we might be led to believe, that maybe it's just a new dividing line between violent offenders and nonviolent offenders rather than a realignment of the system. So our new reform, it distinguishes between low-level offenders and real criminals, okay? So we have the folks over here, the drug offenders, the nonviolent offenders, and then we have real criminals. One is worthy of reform, the other still deserves greater punishment. So we're trying to reassure the public that real criminals will still be punished. And there's also a suggestion, well, if we just reform the drug laws, that we are going to solve the problem of mass incarceration. But if you'll recall that really cool, colorful pie chart that I showed you, that big chunk of state offenders that was violent offenders, they're not going to be touched by this reform. So that's, close to a quarter of our incarcerated population. So it's not a panacea. It's not like we get rid of the crazy drug laws, we're all of a sudden going to have a lower incarcerated population in the United States. It will have an impact, but not as big as I think some people might think. So is it a rethinking of the intensity of our punishment practices, or are we just kind of moving the boundary, right, and still preserving harsher than most countries, still preserving that over here for what we consider the real criminals, and then separating out the folks that we believe are more deserving of leniency and mercy. I have this on my last slide. This is a really great source because it collects all the social science. And as I said, I'll have that on my last slide for anybody who wants to follow up on that. So here's the things I've been thinking about and researching a lot lately. What can impact reform, rhetoric and narrative? By nature, this is emotionally charged stuff. And that means it's highly susceptible and highly manipulable to symbolic politics, okay? I think we've seen that throughout at least modern criminal justice. So I think we have to be wise and thoughtful consumers, just be aware of that, okay? Be thoughtful about when people are using heavy rhetoric and ask what's behind the rhetoric. Path dependence. We've certainly seen this in the entrenchment. Once we have mass incarceration, we got lots of prisons, we have lots of prison guards, we have the bail industry, and those vested interests will seek to perpetuate those systems, okay? Once we start outsourcing and privatizing justice, and who can blame them, right? We're a capitalist society, that's our motto, is we make money, but once we allow people to make money off of prisoners and detainees, then we're kind of risking creating some vested interests who will work hard and fight hard to keep their share of the pie. And money. Money. And there's a couple, I think, recent developments, recent within the last 10, 20 years, that I think are changing the nature of criminal justice reform. Is one, the loosening of campaign finance restrictions and fewer reporting requirements, less transparency around campaign financing, makes it easier for money to come in to lobbying and reform efforts without detection. So something to think about. How is it different now than it was before? What I call the new face of philanthropy, Marcy's Law. We also see this in bail reform. There's a group called the Arnold Foundation, also founded by a billionaire, who's a big proponent of data-driven pretrial detention algorithms. I lived through the federal mandatory sentencing guidelines, so I'm not sure I'm a huge fan of numbers. I think they're a good starting point. But again, we have one individual who has made it sort of his mission to reform bail detention decisions, and he offers his algorithm to jurisdictions, many of, like in Montana, that are cash-strapped, right? He says, here, you can have this computer-based program. You can't tinker with it. You can't revise it, but you can have it for free. So something to keep an eye on. But I think this is new. It used to be wealthy individuals would give their money to organizations, and I think there's more and more of a tendency for wealthy individuals to create their own organizations to pursue particular interests. And then the internet, right? It's changed everything. And so we can get rapid mobilization around criminal justice system, but also rapid dissemination of information and misinformation. And if you tie it back to the rhetoric and narrative, that can feed on itself in criminal justice, where people have a perceived sense of danger, perceived sense that something needs to get fixed, so there's a problem that can be kind of hard to dislodge at least some of those narratives. Okay, so right on time. So here's the things. Now that you're the newly educated and consumers of criminal justice reform, the things I want you to think about, hopefully, when you're out in the world and you see some criminal justice reform coming your way. So what does it target? What are we trying to do? Is it the punishment part? Is it the procedure part? Who supports it? Who opposes it? Generally speaking, if there's something that is a change that is proposed, let's say in the medical profession, and the AMA is behind it, right? So let's say it's a cure for some disease, and the AMA says this is great, and then there's one pharmaceutical company over here says, no, my product is better. I'm going to think about where it's coming from. So I'm not saying just you should always believe lawyers. I would never say that. However, I will say if the entire legal profession is opposed or behind something, that might be something to think about. Okay, if the entire legal profession, it pretty much does think the bail reform system needs to be amended, something to think about. Who's behind it? Is there consensus, or is there consensus among affected groups? Is it bipartisan support? I think that matters. I think that matters a lot. Or is there a political agenda here? Is it homegrown or imported? Okay, next time an issue comes your way, say, hey, where'd this come from? Come from California? Did it come from North Dakota? Did it come from Montana? Is this our problem? I think that's the real deep issue there. Is this a problem that we need to address? Is this a Montana problem, or is this somebody else's problem? Is it a people's idea, a billionaire's initiative? Who profits from it? Is somebody going to make money off of this? Who pays for it? You and me, probably. Who does it impact? I can guarantee you, because most of the people in the criminal justice system are poor, criminal justice reform, one way or the other, is going to impact poor folks, but not just them, their communities, their children, their neighborhoods, and future generations. And most importantly, what is the evidence that there's a problem? Is there even a problem? Sometimes we want to change things because of a narrative or because of a newspaper report. So find out. So what's behind it? Is there a problem? What's the evidence that the reform will address it? And my last slide is, I'll leave this up. So here's some sources that I relied on pretty heavily and that I also recommend for consumers of criminal justice reform if you want to follow up on any of this. So I thank you very much for your time, and I'll be happy to entertain questions. Thank you. Are you on that?
When people figured the cost of incarceration, do they also figure in all of the social services that end up being required by families of the incarcerated?
No. I take your point. I mean, we need to be thinking about this. So, the interesting thing about money in criminal justice reform is one of those things, you can pay here, you can pay there. Kind of one of the, it's not a big secret in those of us who work in criminal justice that actually one of the biggest payoffs you can get in terms of criminal justice reform is early childhood education. Head Start. Somebody want to reform criminal justice system, I want to talk to you about social services. But that's not the dialogue people want to always be in, right? We have crime and punishment, that morale, we lose that morality, that sense of the morality play. But if you look at front end and back end, you get so much bang for your buck if you're willing to pay up front, early and community reinvestment and things like that. It's, a direct relationship between community trauma and individual trauma and who ends up in the criminal justice system. I can give you that profile, right? Male, poor, substance abuse, origin of family of origin, history of violence, substance abuse, physical abuse, okay? So that's my answer to your question. Are we factoring in those other costs? No. Should we be? I think so.
Where are all the private Montana prisons?
So we have a handful. Shelby's one of them, and then we have a couple private jails. But do you know where they are? What's that? Is there one in Hardin? There might be one in Hardin. Shelby, right. I wish I knew the answer to that. Somebody might, though. Most of our folks are in Deer Lodge, though. We have one main prison.
Am I next?
I think so. You've got the mic.
Okay, so thank you for your talk. It was great. I want to just add a caveat. I think it's important to consider the role of correction officers unions in some of these tough on crime reforms. They certainly have been involved, and they certainly have been involved advocating policies that were not progressive. The California Correction Officers Union is really an outlier in a lot of ways. I don't think it's fair to say they were able to achieve this and this, and that represents all correction officers unions. And there's a great book that you probably know about called The Toughest Beat by Joshua Page, who's a sociologist who wrote a history of that union. And the extent to which they were extremely conservative and the extent to which they were extremely powerful is different than most correction officers unions, I would say, in most states, not all. But I think they're an outlier.
I think that's fair. I think it's worth noting that California has one of the largest incarcerated populations, so it might have an outsized impact on reform just by sheer numbers.
Well, and because of that, their correction officers union is much bigger than it is in any other state.
Right, that's the point. Yeah. More criminals, more officers. Yeah.
So my other question is about your periodization of the war on crime, which certainly 1960s, 1990s. But I think we're entering a new era of a new war on crime in the United States. I mean, I think our war on crime today really targets immigrants and refugees, and perhaps we'll see a resurgence on this war on drugs narrative. So I was wondering how you could talk about that period and what you think about whether we're going to see a new resurgence today.
So, and I think that's fair. I wouldn't say the war on crime is over, but it definitely can be compartmentalized around the narrative. I guess that was my whole point. Who was using the language? It was Nixon. It was Reagan. It was kind of this period where the language was, we're fighting a war on crime and a war on drugs. If you think about what people are talking about now, we have the opioid crisis, but it's more of a therapeutic approach, which I find incredibly interesting because the folks who are using opioids tend to be disproportionately white and non-minority. So all of a sudden we've adopted a therapeutic approach to drugs, whereas before it was a military approach. Does everybody remember the battering rams in the 90s and busting the doors down? So I don't mean to suggest it's over, but I do mean to suggest there's a distinct narrative and the distinct period of sort of this ramping up of harsh sentencing laws and drug laws. And that now we're retrenching. Now we have the Reinvestment Act, as in Montana, and we're walking away from some of that. So I think that's kind of a dividing line, if that makes sense, going from the harsh laws, the drug laws, the mandatory minimums, and we're definitely walking that back, generally speaking, nationally. We're walking back the harsh sentencing laws. Immigration is a class by itself because that's federal law. So remember our pie, this is mostly state and local. But when we talk immigration, that is 100% federal. And much of immigration laws tends to be administrative law. It's not actually criminal. And it has its own, as you might have, I don't know if you saw this in the news recently, there was a really important bail decision that came out of the U.S. Supreme Court that immigration detainees are not entitled to a bail hearing. So we take immigration, whether for right or wrong, but legally speaking, that's its own little segment over here. Yes, is there a new narrative that there's an other? Absolutely. Is there a new narrative around that? But I don't see that as part of the criminal justice reform writ large. Does that answer your question? I think really fair points. About the correctional, and I didn't mean to slam on correctional officers. The whole point is there are entrenched interests and there are vested interests, and the unions have had a seat at the table, rightly so, but aren't always aligned with reducing incarceration rates, because those are jobs. Construction of prisons, those are jobs. Okay, I don't fault the construction industry or correctional officers for wanting to think about whether the retrenchment is helpful or not to their financial interest, but there is an interest there. Hi, Holly.
Hi, thank you, Jordan. This was, is this working? Very interesting. So, as you know, I work in the natural sciences, and I thought that climate change was disheartening, but this is even more.
Wait, is there a disheartening award? Do I get it?
So, can this be fixed?
What's it?
The law for justice. Once I was in a book club, and I said, very naively, as usual, I said, but the law should exist for justice. And they all look at me like I was an alien, like, what world do you live in? So, you know, the rich are getting richer, the poor are getting poorer. There is, am I looking at this right? There is no outlet for law for justice?
So,
Sorry, this is
no,
not.
it's a big question, but I like the question. But it also goes back to this woman's point about social services. So if you want to fix criminal justice and bring our incarceration rates more in line with other industrialized nations, it's not criminal justice that needs to be fixed, it's the social fabric, okay? I think one of the greatest perpetrators of the criminal system, or like one of the biggest feeders, is opportunity inequality, right? And what you just talked about, income inequality and educational inequality. So I think it is one of those things, is maybe we've chosen to live with it, I don't know, but I do know that investment in early childhood education, in community programs,
Sure, but
pay off on the big end, on the back end, and they pay off big.
Right, but as long as the rich benefit from not doing that, it's never going to happen.
Well, don't say never.
I mean, like, I was listening on NPR the
Yeah.
other day, and probably I might portrayed wrong, but Portugal had an enormously rampant drug problem, enormous amount of incarcerations because of drug, and what they decided is make all drugs legal.
Legalize it, yep, and
All
provide
of
treatment.
them, and the drug abuse has declined a very significant amount. So is the public ever and the lawmakers ever going to look this type of evidence?
Well, I think we're seeing this new narrative, this therapeutic approach to the opioid crisis. I hesitate to use that word because, again, that's part of a narrative, right? You're buying into those words. But I do think now that we're trying to peel off drug offenses, nonviolent drug offenses, the danger is we create these two classes of criminals. But I do think that sensibility is there. On multiple levels, it doesn't make any sense. It's, I think, you know, widely accepted that it's an illness, right? Drug abuse addiction is an illness, not a crime. And also we get better payoffs if we treat it therapeutically. So I do think there's an effort to walk some of it back, but the point is that violent offender category, it's not like they're getting any relief from justice reform. And then you get an entrenched kind of hardcore criminal population that's still going to be way out of whack with the rest of the industrialized world. So I think there's some movement and some positive movement there that will reduce incarceration rates and hopefully redirect some resources towards treatment.
Hi.
Oh, hey, Jason.
Maybe you touched on this before I came in, but first question is, what have Vermont and New Hampshire done to reduce their prison population?
Things like, yeah, reducing the recategorizing crimes, taking things from felonies to misdemeanors, making no jail offenses, right? That's a concept that a lot of jurisdictions are looking at, because even low-level misdemeanors, as you know, are in Montana, you can go to jail for some pretty small offenses. So recategorizing offenses and decriminalizing some conduct as well.
Do you have any sense that prison overpopulation and jail overcrowding have eroded the right to a speedy trial? Has that affected it in any way?
You know, I don't think it has, simply because everything so much pleads out,
Okay.
right? What do 95 to 98% of cases go out on plea bargaining? So has it eroded the right to this? That's a good question. I don't think it has. I don't think it has. Now, if people stopped pleading guilty, it would, right? You'd have to, you know, they often say if everybody refused to engage in plea bargaining, it would bring the system to its knees. But you're going to be the first one to go? I'm not pleading, right? Thanks.
Fascinating figure to me was the 5% or 5 times the number of people in countries of similar development. And does anybody, in thinking about this, think that the availability of guns and would have anything to do with that? In other words, you know, what makes us so different? I don't think we're that more immoral or whatever, but the one thing we do have is we have the most guns in the world of any people that aren't at war.
You know, I think your point is well taken, but I wouldn't say that those violent offenses are necessarily gun offenses. I'm not sure I don't know the research of whether that's the driver. My understanding, at least of the social sciences research, it's a culture of violence, not necessarily of handguns and you know, weapons of war. And that there is maybe a more violent response to some things by Americans. So that one's hard. You know, who knows what makes us what we are? But are we a more violent people, or do we define more crime as violent? I don't know the answer to that. But I do know, going back to the family of origin and communities of origin, we have a much different history than many countries in terms of our racial disparity, but also in terms of our economic disparity. So we have communities that have been subjected to the violence of poverty. And sort of historical trauma can go a long way in some people's research, according to some people's research, in explaining that culture of violence. So I'm not sure I would say it's guns. It doesn't help if you have people who are more prone to violence who also have guns, perhaps. You know, that could be a bad mix, but I'm not sure that's what's driving violence. But I don't research that area, so that's from the lawyer's perspective.
Talking about providing social services for children as a way to create reform in this major topic, how do we make that not just a liberal narrative? How do we make that actually be something that people buy into as a cause and effect type model?
Called a Reinvestment Act, right? A data-driven, evidence-based reinvestment. I don't get it. I wish I knew your answer, because anybody who is a lawyer in the criminal justice knows that. It's not a secret that if you spend money on the front end on quality education, that you get big payoffs on the back end. I wish I knew the answer. I would have solved this whole thing by now, right? If I knew how to push that narrative forward. So I think it has to be some combination of finance, right, money. We're kind of, all these Reinvestment Act narratives are about saving money, but it still needs to be, because we're not talking about the human cost anymore, the human cost and benefit. So I don't know. If somebody else knows how to move that forward, but I didn't come up with this. Like I said, this is not a secret.
Hi, Jordan. Yeah, thank you very much for this illuminating information. You talk about narratives, and you talk about looking also at the source to see, is this coming from the people? And I think the narrative that you use regarding the people really comes out of that the common law and the the old way of you want to rehabilitate and bring somebody back into society. For example, if the person that is my baker does something wrong, but I need him for bread, okay, there's some kind of public shaming, he comes back. I feel like the narrative might be changing. People don't need each other in that way, and if you look, and I know that as a social scientist this is dangerous ground, but if you look at Facebook, there's always
don't.
posts about
Just saying.
lock them up, lock them up, lock them up.
Right.
And what we know, though, is that the more we expose people to that kind of messaging, the more they're going to adopt those kinds of ideologies. So our movements from the people, that to me is just a scary notion. So I guess how do we control for that?
Right. How do you control that internet piece? And we've seen that recently with fake news and election tinkering with elections. Placing fake stories on the internet, and I don't know, but it is frightening that something can catch on like wildfire, and to be seen as the public voice or the people's voice when it really isn't. And I think a big part of it is people being educated and asking questions about reform. Whose is this? Where'd it come? It's like, do you know where your vegetables came from? Do you know where your reform came from? I don't know how you can, information is more, you counteract with more information.
When do you know, are there studies showing the sort of shift in that attitude against rehabilitation and toward incarceration?
That I don't know. About people's attitudes. What's interesting about this Reinvestment Act, it's really driven by state governments. Okay, this is not sort of the people saying, I know there are pockets of people say, hey, we lock up too many people, but these Reinvestment Acts are very much coming from a centralized think tank, which doesn't make it a bad thing. It actually makes a better product, I think. But it is a matter of dollars and cents. It's a matter of fiscal responsibility for state governments. That we can't keep doing this, right? Because you lock a bunch of folks up, but there's not a lot of federal money. There was some federal money. That's the other thing, is to think about the money. Some of it dried up after the war on drugs, whenever that did end, the war on crime. There was an awful lot of federal money on the ground for law enforcement, for corrections. And some of that has gone away, and some of it's been redirected. And I think that it can be a big driver of reform, too, is when the federal government starts withholding money. So I don't know. That's my answer to Shane.
Jordan, I had a question.
Yeah.
In your discussion of the going through the system, you didn't touch much on prosecutorial discretion. Where do you see that in the mix of all these things that you've been talking about?
So yeah, good point. So that's huge, and that's also a defining characteristic of the American criminal justice system. In some countries, prosecutors don't have discretion, okay, but they also don't have as many laws. So here's how it works in our system. The legislature passes lots of laws, just by way of side. Does anybody know how many federal criminal laws there are? Trick question. Nobody knows. Not even the federal government knows, okay? Between 3,000 and 4,000. We're probably violating several right now as we speak. So the point being, it works like this. Legislatures pass a lot of laws, so they can be seen as being proactive and tough on crime, but the reality is prosecutors don't charge them all. They pick and they choose. In some countries, prosecutors have to charge everything that is supported by probable cause. That's because other countries don't have quite as many laws. So prosecutors have unfettered discretion. The U.S. Supreme Court says there is no constitutional limitation except if it's vindictive or discriminatory. A prosecutor can charge whatever she wants. So that means, armed with mandatory minimums, right, and big sentencing, big drug sentences, prosecutor can come and say, well, I'm going to charge you with this offense, but if you're willing to talk, I'm going to let you plead to this offense with the lower punishment. So it is a big driver of plea bargaining, certainly, and a big driver of our system. There have been suggestions we should abolish prosecutorial discretion. I don't know how that would happen, but that would have a huge impact, I think, in at least making sure that charges are aligned with the actual conduct. Because right now the practice is to charge the highest offense possible based on the conduct, knowing you're going to walk it back to a lower offense. Does that answer your question? Yeah, thank you.
Yes. Okay. I don't know if there is anyone that wants to ask a question. I already asked one, and I'm not even sure it's a question, but the gun reform is a good example of law being driven by money, and being driven also by a little bit by the public. So as I see, the number of gun deaths is orders of magnitude from any other country. It's the problem is greater than any terrorism, etc. And yet here we are. We cannot change the laws, and unfortunately, the marketing for the people that benefit from the money is dead people, right? So that's scary, and everybody wants to defend themselves. So how do you beat that?
So I love this question. I think this is our last one. I get to leave us on a high note, because what just happened in Florida? A bunch of teenagers got the state law changed by marching on the Capitol. That is the power of the people.
But that's the unexpected people. So
yeah, but look at that. Florida, a gun rights state, with a conservative governor who took on the NRA and changed state law. So I love it, because it does not give us hope for reform. So I think it's those organic, genuine expressions of the people can lead to real and lasting reform. See, that was the perfect place to end it. Thank you, Anna. Thank you so much.
Thank
I
you.
really enjoyed my time with you.
We'll see you again next week.